really bad. Okay, escrow closing. Okay, we talked about a roundtable closing and escrow closing. A lot of the same elements are happening. So the deed is delivered by a grantor to an escrow agent. The escrow agent is typically the title company, who is directed to deliver the deed to a grantee when specified conditions are met. So I've got a title company. They're standing there. They're getting all the documents for the sale. They've got the deed. They've got the buyers giving them the money, the check. So everything is happening. Probably you are getting that 3-day notice. Literally, you can have that time frame. So everything is delivered to this one escrow agent. So the escrow agent closing is not confused with an escrow account. It's an agent. It's the person at the title company. We've said, hey, we want you to control this. We're not going to necessarily do roundtable. The buyers are going to come in one time. The sellers are going to come in one time. And the roles of the seller and buyer are very similar, but they're not done around a table now. So the advantages: often inconvenient for the parties to be present at a closing, protection against the party's change of mind. Both buyer and seller are to some extent protected from the other's change of mind, bad feelings, things like that. Avoids the confrontation of conflicting interests and personalities. Again, the seller came to the escrow agent, signed all their paperwork, did all the deeds. The escrow agent then maybe meets later that day or the next day or the next week even with the buyer and turns the keys over to them and gives them the document and everything, if it's going to be a key closing. It's a valid deed, same kind of thing. The deed has to be executed properly. Enforceable contract. This is where the escrow agent is going to say, hey, I need the contract so I can determine everything that's going on with the transaction. It happened before in the roundtable closing, but here all the escrow agent has is a contract to wait, and one party comes in, another party comes in. So in the absent purchase contract, the deposit of a deed with an escrow agent cannot be the subject of valid escrow. They're going to look for a contract. Delivery, surrender of possession, control of the document, third party depository. Now we haven't talked about actual possession of the house yet or keys. All we're doing is documents right now in an escrow closing. The escrow agent's third party. Neither the buyer nor seller should act in the capacity of escrow agent. They're not, should not. The escrow agent may not act contrary to escrow instructions. So they've been given a deed, a document that says these are the instructions. This is how you're going to run this closing. If a title search shows the title's not free and clear, the escrow agent has to return the deed and purchase money to the respective parties. The escrow agent says, stop, we can't have a closing. I'm going to close it all down. I'm giving everybody their stuff back, and we're going to start over. Yes, the contract can still be going on. We can start over. They're not making it invalid. They're just saying, heads up, we can't complete. We got to get this done right. An escrow transaction involves property. The escrow agent is the relationship of trust to the parties involved. When the escrow agent embezzles escrow funds, and this happens, the buyer or seller bears the loss. While the escrow agent is liable, it's difficult to collect against an absconding or incarcerated escrow agent. But, again, when we choose escrow agents, we want to choose a title company, like a Chicago Title or something like that. So if somebody does abscond with funds, guess what? Chicago Title is a big company. They can cover, they can take care of it. You're not going to the agent, you're going to the title company to have them be your escrow agent. So the advice is, when you're using escrow agents, get a reputable company to become your escrow agent. So there's money backing them up. Somebody's not going to take these. The real estate agent is going to make referrals. The buyer and seller get to choose the escrow agent. Yes, but the real estate agent is going to make referrals. Again, this is part of that toolbox you have of the referrals. Who can help me get a deal done? I recommend this company. I've done business with this company before. There's plenty of good title companies out there. And you can give them 3 or 4 title companies that are good-sized companies that if anything happens, they're going to still be protected.
Like Lawyer's Title over by Walmart.
Lawyer's Title is a good, big company. There's a lot of title companies out there that can do this. Again, but I wouldn't say just use a small company. Don't just go to a law firm. I would say go to a large company. If we're going to have an escrow closing, to make sure all the parties are protected, let's make sure there's big money behind what's going on. Escrow agreement, an agreement that directs the escrow agent regarding terms, conditions under which the deed or the other instruments are to be delivered to the parties. and the disposition of the deed or the other instruments on default. So it's not ready to close. Somebody backs out, defaults. How are we going to stop this transaction? Where are we going with it? All those instructions are there in that escrow agreement. Bless you. The escrow may be used to require any number of conditions to attach before the deed and purchase money pass to respective parties. Again, the escrow agent is the title clerk closing, making sure all the things are satisfied to make the closing happen. They're the ones that can shout out and say, hey, wait a minute, we need this, we need that. I can't close until I get all this. I'm going to postpone a closing till I get all these things done. Title passage, still 2 deliveries. First delivery is accomplished when the grantor surrenders control of the deed. The second delivery occurs when the escrow agent surrenders the deed to the purchaser after the occurrence. So within that second meeting, they signed the mortgage. They did the note, and they stuck the property to the mortgage and all that. That was the second piece of the roundtable closing. But here they're saying the second delivery is when they actually are ready to give a deed. So a couple days have probably passed between the time they met with the seller and the buyer to be able to give them the deed and do what they're going to do. Relation back. This is something, keep in mind, you will get something like this on a test. It's a legal doctrine whereby the title acquired by a deed relates back to the moment of the first delivery to an escrow agent. The reason this is important information to understand is people die while sale transactions are going on. So how do we say that the transaction still is going to go on? We have this relation back theory. Death and disability. Under the doctrine of relation back, the passage is deemed to have occurred while the grantor was living. This doctrine is similarly applicable to insanity or other disability. So the person was of sound mind. They started this whole closing process. They were in an accident. Something happened. They are no longer of sound mind, but they already was the grantor. They were already going to sell the property. Relation back says we're going back to that moment where they had clear, knew what was going on. They agreed to a contract. We're still going to make this contract happen. It's still happening. Well, an estate, the person dies. The estate isn't as much as the kids or whoever may want the house. It's the executor's requirement to deliver the deed, deliver the house, and do what's going to happen under relation back. So relation back, this can be a roundtable closing or it can be an escrow closing. This is still something that happens in our real estate world. If people die during this time of things, if the buyer dies, the deal's done. No matter when it happens, the deal's done. Because the buyer is not going to be able to finance and keep the commitment to pay a mortgage. It's done. But when the seller dies or something happens to the seller, relation back says we still have a transaction. It's still a good transaction. It can still happen. Dower. Doctrine of relation back may protect the purchaser from a dower claims by the seller's spouse, where the spouse of the deceased seller had no dower expectancy at the time of the deed was deposited in escrow. So they had a divorce, or not yet, but things were going on. Intervening liens. Application relation back may avoid problems caused by liens, encumbrances, and judgments that attach the property between the time of the first and second deliveries. So this relation back theory is basically saying that when that person was alive, when they were sound mind, they signed this contract. They were going to sell their property to me. Stuff happens in between all the time, but it still says that when they said everything was good, we can still carry on and make the contract happen. And that's it. Any questions? Okay, I told you I'd have you out of here early.